Bismillahirrahmanirrahim. Starting in the name of Allah. Today I will discuss about cancellation of an instrument. So our question is, what do you mean by cancellation of an instrument? What are the conditions of cancellation of deed? Who can seek such a relief on what grounds? Can a party to a disputed document maintain a suit for a mere declaration that the document in question is first one and it is not binding upon him? Okay, so now we are going to see the answer of this question. Cancellation of an instrument. Cancellation of instruments means a decree of cancelling a deed. Okay, so cancellation of instrument means a decree of cancelling a deed by a court under section 39 of the Specific Relief Act 1887. Okay, with regard to a void or voidable deed. With regard to a void or voidable deed. Okay, according to section 39 of the Specific Relief Act 1887, any person against whom a written instrument is void or voidable. So any person here against whom a written instrument is void or voidable, who has reasonable apprehension, which person, any person against whom a written instrument is void or voidable, or who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury. Okay, if left outstanding may cause him serious injury. Okay, any person may sue to have it adjudged void or voidable, and the court may in its discretion so adjust it and order it to be delivered up and cancelled. Okay, so from this bare section, we have understood that the court can pass an order to cancel a deed when any person, okay, the person against whom a written instrument is void or voidable, or who has a reasonable apprehension that such instrument may cause him serious injury. Okay, if left outstanding, that means if he left outstanding of that deed, okay, it may cause him serious injury. Okay, that person may sue to have it adjudged void or voidable, and the court may in its discretion so adjust it and order it to be delivered up and cancelled. Okay, the court with its discretionary power may pass any order regarding cancellation of such deed. Okay, so now we are going to see a condition of cancellation of deed. In order to get relief of cancellation of deed, the following conditions must be fulfilled. Okay, which conditions? These are written instrument must be void or voidable against any person. So it is a first condition. Written instrument must be void or voidable against any person. There must be a reasonable apprehension that the such instrument, if left outstanding, may cause him injury. Okay, it is second condition, and third condition is the injury must be serious. Okay, and fourth condition, there must be reasonable cause to pass an order to cancel the deed. There must be reasonable cause. Okay. Next, fifth condition, suit for cancellation of deed must be filed within 3 years under Article 91 of Limitation Act 1908. And last of all, the plaintiff must file his suit with clean hand. That means the plaintiff must have a right, okay, and he must come before the court with a clean hand. Okay, who can seek our relief? Now we'll see that the following person can bring a suit for cancellation under Section 39 of the SR Act 1877. Any person to any party to instrument, so from this part we have understood that any party of the instrument, that means of the deed, he can file a suit before the court. Okay. And next, any person who is affected seriously. It means to get the relief of cancellation of deed, there is no mandatory provision of being a party to the disputed deed. So any person can file a suit. He must not be a party of that instrument. Okay. So from second criteria, we have understood that any person can file a suit under Section 39. Okay. Next, the grounds for a cancellation. In order to get relief of cancellation of deed, the following 3 conditions must be fulfilled. Okay. The deed in question shall be either void or voidable against the plaintiff. In question shall be either void or voidable against the plaintiff. Okay. Next, the plaintiff must have a reasonable apprehension that if the deed is not cancelled or if the deed remains as it is, then he would be affected seriously. Okay. So there have a reasonable apprehension. Okay. And next, if the court finds that the plaintiff would be benefited if he gets the relief of cancellation of deed, then the court by its discretionary power may pass an order of cancellation of the deed. So here are 3 situations. The deed in question shall be either void or voidable against the plaintiff. The plaintiff must have a reasonable apprehension that if the deed is not cancelled or if the deed remains as it is, then he would be affected seriously. And if the court finds that the plaintiff would be benefited if he gets the relief of cancellation of deed, then the court by its discretionary power may pass an order of cancellation of the deed. Okay, now we are going to last part of this question. Can a party to a disputed document maintain a suit for a mere declaration that the document in question is first one and it is not binding upon him? Okay, it is our question. Now we are going to see the answer of this part. According to Section 39, any person to the disputed deed can file a suit to cancel the deed. The general principle with regard to cancellation of deed is that if any person wants to cancel the deed, then he or she has to file a suit under Section 39 of the Specific Relief Act, and he will have to fulfill the following 3 conditions under Section 39. In order to get relief of cancellation of deed, the following 3 conditions must be fulfilled. The deed in question shall be either void or voidable against the plaintiff. The plaintiff must have a reasonable apprehension that if the deed is not cancelled or if the deed remains as it is, then he would be affected seriously, and if the court finds that the plaintiff would be benefited if he gets the relief of cancellation of deed, then the court, by its discretionary power, may pass an order of cancellation of the deed. Okay, in fact, two types of people can file a suit for cancellation of deed under Section 39 of SR Act. Firstly, any party related to the disputed deed, and secondly, any person who is not a party to the deed. So here, firstly, any party who is related, okay, to the disputed deed, and secondly, any person who is not a party to the deed. Okay. In the case of Abdul Hamid versus Dr. Sadiq Ali Ahmed, 21 DLR 507 page, the High Court Division held that there is a difference between a suit for declaration that the instrument is not binding on the plaintiff and a suit for cancellation of an instrument. Okay. So it has been further held that where a document has to be set aside or declared null and void by a person who is a party to the deed, a mere declaration would not do, and a cancellation of the deed is necessary relief unless the document is void ab initio. So it is very important, unless the document is void ab initio. Okay, then mere declaration would not do. Thus, while the plaintiff is a party to the concerned deed, he must frame two specific reliefs in the prayer of his petition. That the plaintiff is not bound by the deed and the deed is void. So it is a declaratory relief. It is a declaratory relief that the plaintiff is not bound by the deed and the deed is void. Okay, second relief, that the deed be cancelled. Okay, it says said the relief of cancellation of instrument. So a plaintiff must have pray for two reliefs. Okay. On the other hand, where a person is not a party to the deed, he need only one declaration relief in the form that he is not bound by the deed, as he is not party to the deed. He doesn't need to seek for the reliefs of cancellation of instrument. Okay. In Shamsuddin versus Begum Arafat 43 DLR 52, it has been decided that where the court finds that the instrument is void ab initio, the suit is maintainable without asking for cancellation of the instrument under Section 39 of the SR Act 1877. Okay, it is very important when the instrument is void ab initio. At that time, we need not file a suit for cancellation of deed under Section 39. Okay, he can rather get relief if he files a suit under Section 42 only. This decision has also been accepted in Sufia Khatun versus Faizun Nessa 39 DLR 46. In this case, the appellate division held that the Section 39 concerns with two types of deed, void documents and voidable documents. Where it is proved that the deed is void or void ab initio, okay, there is no need for prayer of cancellation of deed. Where it is proved that the deed is void or void ab initio, there is no need for prayer of cancellation of deed. On the other hand, where it is proved that the deed is voidable, then both the prayer for declaration and cancellation are required. Okay, so where it proves that deed is voidable, deed is voidable, then both the prayer for declaration and cancellation are required. In the above case, the appellate division further held that if the plaintiff only makes prayer for a declaration decree under Section 39 but doesn't ask for cancellation of document, then the court should not dismiss the suit. Instead, the court shall rather ask for additional court fee and grant the prayer for cancellation of deed. Similarly, in case of a suit filed under 42, if the plaintiff makes only prayer for declaratory decree and doesn't ask for cancellation of document, then the court shall either dismiss the suit or direct the plaintiff to pay additional court fee. However, it is to be emphasized that where the deed is void or void ab initio, there is no need to make any prayer for cancellation of the deed. Okay, if the instrument has been registered under the Registration Act 1908, the court shall also send a copy of its decree to the officer in whose office the instrument has been so registered. So it is important for understanding, if the instrument has been registered, okay, under Registration Act 1908, the court shall also send a copy of its decree to the officer in whose office the instrument has been so registered. While an instrument is evidence of different right or different obligation, the court may, in a proper case, cancel it in part and allow it to stand for residue. Okay. So it is mentioned in section 40. Period of limitation. According to Article 91 of Limitation Act 1908, a suit can be filed within 3 years under Section 39 of the SR Act 1877. Court fees. Plaintiff must give ad valorem court fees. Okay, that's all about a cancellation of instrument. Thank you for watching this video.